My name is Rachel Royal, and I am a member of the North Carolina Justice for All project team. The group is also comprised of co-authors Alicia Mitchell-Mercer, S.M. Coronado-Hodges, and contributors Shawana Armendariz and Morag Velasquez. Most of the information I'm going to share in this video can be found throughout our website, but we have recognized that you may not have the time to read all of that information, or that you just prefer to listen to it. So this is a short summary of our project and purpose. The Justice for All project team is advocating for legal regulatory reform. On January 22nd, 2021, we submitted to the North Carolina State Bar and Supreme Court a proposal seeking changes to Chapter 84 of the General Statutes to allow for limited licensing of paraprofessionals. Our mission is to offer affordable options for legal assistance to the low-income communities of North Carolina who are not able to be served by legal aid providers. We want to eliminate the dilemma of citizens having to choose between navigating the civil justice system on their own and not seeking remedies at all for legitimate legal problems. We were inspired to implement this idea by other jurisdictions that have recognized that access to justice is a nationwide problem, as well as the civil legal needs assessments performed in 2017 by Legal Services Corporation and in 2021 by the Equal Access to Justice Commission. Our research shows that when people have access to affordable legal assistance, there is a positive economic impact that allows state and federal funds to be redirected to other community needs. Affordable legal counsel will also reduce court backlogs caused by pro se litigants who are unsure how to navigate complex civil procedures and local rules. Our proposal was created with the best interests of the public in mind. While limited licensing of paraprofessionals could offer another tier of legal services similar to nurse practitioners and physician's assistants in the medical field, this isn't the primary purpose of the changes we are proposing. Our vision is that licensed paraprofessionals would charge significantly lower fees than attorneys in order to offer legal counsel to more than 1/3 of the state's population who would never be able to hire an attorney at all due to cost restraints. While law school would not be required for the contemplated license, we do believe that a combination of education, paralegal certification, experience, and examination should be utilized to ensure that the public are receiving quality services at a much lower cost. The proposed license would be of limited scope, meaning that a limited licensee would need to have actual experience in the field in which they intend to practice, and they could not simply decide that they want to practice in another area without the proper education and examination. The goal is to offer services in the areas of highest need as identified in the 2021 North Carolina Civil Legal Needs Assessment, which includes family law and landlord-tenant issues. Licensees would also be required to take continuing legal education, just like attorneys are. The current proposed practice areas are some areas of family law, landlord-tenant law, debtor-creditor issues, expungements, simple estate planning, and administrative law. We have received some feedback and concerns about the proposal, which we address on our website. One of the often stated areas of concern is the potential for public harm. We believe the requirements and limitations for the license would prevent this. Our research shows that other jurisdictions that already allow limited paraprofessional licensing have received a much lower percentage of complaints against non-lawyers than against lawyers in the same time period. We believe that this is largely due to the fact that an attorney who has just passed the bar exam is permitted to practice in any area of law without actual experience, whereas licensed paraprofessionals must have substantive experience in an area of law before receiving a license to practice in it. Further, we believe that the danger that pro se litigants are causing to their own cases far exceeds what they would receive from a licensed paraprofessional who is already familiar with civil procedure and knows how to follow local rules and complete forms correctly. We respect lawyers and the time, effort, and education that it took to achieve their license. We're not trying to replace that license by any measure. Law school and continuing education are expensive, so we understand why lawyers need to charge these fees. We do not expect that limited licensees would be taking business from attorneys, but rather building a completely new client base that attorneys cannot reach due to cost. Individuals who can afford attorney's fees will likely always want to retain an attorney over a limited licensee. Law firms could also benefit financially from hiring limited licensees because they would be able to capitalize from the demographic that they would otherwise not be able to reach. Another often cited concern is that there is limited data to prove that licensing of paraprofessionals will increase access to justice. We disagree. There is already data from long-run programs like that in Ontario, Canada, as well as preliminary data from newer programs like those in Washington State, Utah, and Arizona. We also must remember that data does not always precede innovation. It will likely take years of licensing paraprofessionals to begin to make a dent in the access to justice problem. But if we do not start now, we will still be having the same conversations years down the road with no result. We also recognize that licensure of paraprofessionals alone will not fix the access to justice problem, but we do believe that it is a necessary piece of the puzzle. Many people presume that legal aid assists anyone and everyone who cannot afford an attorney in civil cases. This simply isn't true. There is only one legal aid attorney for every 8,000 North Carolina residents. The yearly income threshold to qualify for legal aid is $33,125 per year for a family of 4. The average rent in December of 2020 for a 3-bedroom home or apartment was $16,740 per year, nearly 50% of that income threshold. That doesn't leave enough money for daily living, much less to pay for an attorney when you need one. Even of the 37% of residents who Legal Aid of North Carolina reports are eligible for their services, only 1 in 10 actually receive the assistance they need. Pro bono service in North Carolina is not mandatory, but rather recommended by Rule 6.1 of the American Bar Association's Model Rules of Professional Conduct. Unfortunately, due to high billing requirements and ethical responsibilities to their paying clients, only about 20% of attorneys in North Carolina actually provide the recommended 50 hours of pro bono service per year. While many paralegals in North Carolina volunteer their time to pro bono service, they can't do so without the supervision of a licensed attorney. Limited licensees could increase the pool of legal providers who can autonomously offer free legal services. Another barrier is that some of the highest areas of need, like family law custody cases, present challenges for pro bono service because of the ongoing nature of those cases. We believe that the legal community has a duty to actively pursue innovation that increases access to justice. North Carolina should learn from the mistakes of its limited licensing predecessors while moving forward to implement a program that will positively impact the quality of life of its citizens who rely on our legal system to protect them. We hope that this video has cleared up any misconceptions about what our proposal does and does not stand for. If you are in favor of our proposal, we would invite you to sign the petition linked at the bottom of our homepage. Thanks for listening, and feel free to reach out to us if you have any questions.